Mr. Martinez, if the Vice President came to you and I want legal advice on whether or not I can violate these limits, because I've heard that somebody said, don't worry about it, they're not going to be enforced. Would you tell him to go ahead? Or maybe one thing would you tell him to do is we ought to be careful because maybe somebody else will be in the White House next term, and they may decide that prosecuting this, what is a violation, makes sense.
Here's what I would tell him, Mr. Chief Justice. I would tell him that Congress has envisioned this exact scenario, and Congress has created in Section 30108 of FECA a specific procedure by which any person can go to the FEC and request an advisory opinion about whether their conduct is lawful. And if the FEC says, yes, it's lawful, as they obviously would here because they think the conduct is lawful, then there is a statutory safe harbor that would provide total relief, total protection to the Vice President from any enforcement action or any prosecution.
Is that true with respect to private enforcement actions?
I don't know whether it's true with respect to private enforcement actions, but, Your Honor, in Whole Women's Health, this court made very clear that private enforcement actions are not a basis to recognize a case against the government. And I think, and I'd have to go back and look, but I imagine that the state safe harbor would apply just as equally to private enforcement actions, because otherwise what would be the value of having the safe harbor? But I concede I haven't looked at that question.
Yeah, that was kind of the point of the question. So you would tell him, don't worry about a thing, go ahead and...
Well, I would tell him there's a statutory mechanism to take advantage of, and I don't see why they couldn't have done that. If they had done that on, when the administration came into power, the president is in control of the executive branch. We heard about that yesterday. I think the FEC would have taken the position it's taken now. They would have given him an advisory opinion, no problem. But they don't want that. They want an advisory opinion not from the FEC. They want an advisory opinion from this court. And that's why they're coming to this court with a bunch of plaintiffs who either don't have statutory jurisdiction or don't have standing. But, Mr. Chief Justice, let me just add to that. Let's say the Vice President said, I don't want an advisory opinion. Tell me what you think. Is this actually going to happen? Is it going to be enforced against me? I would tell him there are 3 layers of speculation that you have to get through, and it's highly unlikely that even a future FEC would change position and come after you. Number 1, they'd have to change their view on the constitutional question. Number 2, more importantly, they would have to do something that the D.C. Circuit has unanimously en banc said is not allowed and violates Rule of Law 101. They would have to file an enforcement action targeting past conduct that occurred at a time when the FEC said the conduct was lawful. The PHH case, unanimous en banc decision ratifying the panel decision, which cited 7 precedents of this court that said that's Rule of Law 101, that's a total due process violation.
Well, I can recall a few occasions on which we have overruled en banc decisions from the D.C. Circuit. So I don't know if that's enough of an assurance to, with speech issues at stake, to say that the case is moot.
I think that the best assurance I can give you is the advisory opinion process. I'm aware that the administration, in analogous circumstances involving other decisions of this court and other precedents, has been giving letters of assurances to individuals confirming that they believe that certain conduct, even when it's not allowed by statute, is constitutional. I think that would be yet another layer of protection in addition to the statutory safe harbor. But I just think as a realistic matter, an FEC that comes in, even if it wants to change position on the constitutional question, is not going to violate Rule of Law 101 by saying we're going to go target a bunch of people who were doing things that we said was allowed. I just don't think that's a realistic concern here. And so if Vice President Vance had that question, I would say we've got statutory mechanisms in place to protect you. Let's take advantage of those. We can go to the administration, which, by the way, you're the number 2 official in, and ask for an assurance letter. In addition, as a real-world matter, it's super unlikely that the FEC is going to violate unanimous decision by the D.C. Circuit, which was written, by the way, by a member of this court, and go ahead and start violating due process by prosecuting people for conduct that the agency said was allowed. It's just not realistic.
I don't